The European Court of Human Rights is the manifestation of Europe's conscience for over 60 years. It is where people turn when their fundamental rights are breached. A court that holds the states accountable to people. Being the last resort for many victims, it is a distant protector yet also the light at the end of the tunnel. The Article 46 of the European Convention on Human Rights stipulates that the decisions of the court are binding for signatory countries. Turkey accepted the jurisdiction of the court in 1989 and endorsed the supremacy of its rulings on the issues of basic rights and freedoms in 2004. Not necessarily a champion of human rights, Turkey does not have a straight A report card from the court. Since 1989, Turkey has been the country with the highest number of violations of the convention. While the highest number of violations has been the right to a fair trial, the following item has been the right to freedom and security pertaining to detention and prison conditions. Recently, the overall protection of human rights went from bad to much worse, in line with the authoritarian drift that Turkey experienced under the Erdogan regime. The alarming situation has been disclosed by many international organizations. Human Rights Watch describes the last 4 years of Turkey as a deepening crisis of human rights, coupled with a dramatic erosion of rule of law and democracy. Under heavy political influence, Turkish judiciary accepts bogus indictments and convicts Erdogan's opponents without compelling evidence. Alongside journalists, opposition leaders, and human rights defenders, the largest group of people convicted like that is the followers of Fethullah Gülen. The Rule of Law Index of World Justice Project ranks Turkey 109th in 126 countries. When it comes to fundamental rights, Turkey ranks 122nd. Only 4 countries performed worse than Turkey. A survey conducted by a research company in Turkey in 2019 indicated that only 12% of the people trust in the judicial system. Let me give you an example about why people think like that. An army general imprisoned with the accusations of involvement in the coup attempt was acquitted after a trial. President Erdogan then publicly stated, "It is a sad situation for our judiciary. I have given the necessary directives." And guess what? The general was rearrested and put back in prison. And this is not an exception. It is how the judicial system works in recent years. President Erdogan complains about someone, and that someone is prosecuted no later than the next day. So much for an independent and impartial judiciary. On the face of all that, the Constitutional Court, the last resort in domestic judicial system of Turkey, threw in towel and became a docile instrument of the Erdogan regime. This photo summarizes the situation. The Chief Justice of the court bows before President Erdogan, expressing a clear subordination. In October 2016, the Constitutional Court itself declared that it had no authority to examine the emergency decree laws with which the regime ruled the country, bypassing the parliamentary supervision altogether. While most violations of human rights were designed and implemented by these decree laws, the highest court of the country resigned itself from doing its job. On the face of such an ineffective and dysfunctional judiciary, the victims, an overwhelming majority of which are Gulenists, seek justice at the European Court of Human Rights. The court then comes up with a cunning idea and proposes the Erdogan regime to establish a commission to deal with the mass injustices created by the decree laws during the state of emergency. It took 4 months to identify the members of this commission. Obviously, the commission is not a court, and it is far from the criteria of Venice Commission and European Court of Human Rights itself. Very clearly then, it was established to delay the applications at Strasbourg. You may think that the court did not want to deal with that many number of applications. But one single decision would act as a precedent and solve the issue altogether. Instead, the European Court of Human Rights chose to remain silent. With the silence, the court, the epitome of Europe's conscience, approves the atrocities committed by the regime in Turkey. The European Court of Human Rights then thinks fundamentally differently from international institutions like Human Rights Watch, Freedom House, World Justice Project, and the overwhelming majority of Turkish citizens that think the judicial system of the country is ineffective. Atrocities, by the way, include making pregnant women give birth in handcuffs, depriving detainees of their vital medicine, solitary confinement, and unfortunately, torture. Interestingly, the court, which rightfully asked for the release of the human rights activist Osman Kavala and the opposition leader Selahattin Demirtas, gives a deaf ear to the misery of 126,000 civil servants who were purged by the Erdogan regime and abandoned to poverty and hunger. In the same vein, the court rejected the case of Gulenists who were dehumanized and persecuted by the regime en masse. These people lost their jobs. Tens of thousands among them lost their freedom. To add insult to injury, the regime cancelled their passports and condemned them to live in misery in Turkey. Rather unbelievably, the European Court of Human Rights expects these people to seek justice in the court system that is controlled by a man who victimized them in the first place. At this point, one cannot help but ask, is the European Court of Human Rights taking a strategic or political stance? If it is, on what grounds? What then is the source of its legitimacy?